So I have an update for you on the current lawsuits against the ATF and their pistol brace rules. This includes the nationwide injunction against that rule. So let's talk about what is now happening with pistol braces. But real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. They have dedicated roasts for organizations like FBC and GOA. So if you want to support the 2A cause and you want to get amazing coffee, I highly recommend you check out Blackout Coffee. You can check them out using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, I have an important update for you on the ATF pistol brace cases. The ATF has now filed their response to the Fifth Circuit Court of Appeals in multiple brace cases that are currently being consolidated at the appeals court level. The ATF now argues that all of the lower courts either got the analysis completely wrong or they issued injunctions that are essentially granting relief beyond what those lower courts could do. And because of this, the ATF is demanding that the Fifth Circuit not only remove the nationwide injunction, but also remove the injunctions which protect the individual organizations like FBC, GOA, and others. You may recall that the ATF recently decided to roll the dice and appeal all the brace cases up to the Fifth Circuit Court of Appeals. Those appeals include the Mock v. Garland FBC case, the Brito v. Garland case, which was recently issued a nationwide injunction, and that was a significant win. Then you have the SAF lawsuit, the NAGR lawsuit, and then also the Gun Owners of America lawsuit. Although the ATF has recently lost multiple cases and even lost at the Fifth Circuit level prior in the Mock case, the ATF has decided that the lesser of evils to them is to essentially appeal all these cases, get them consolidated, and hope that now the Fifth Circuit changes their mind. The ATF argues that despite that Fifth Circuit ruling originally in Mock, the lower courts were wrong in following that ruling. They say that that ruling in Mock should not have led to other decisions in the lower courts, which ultimately struck down this rule. They also double down by saying that the relief granted by the lower courts, including the Brito nationwide injunction, is too broad and therefore must also be struck down. Now, if you're not aware, recently in the Brito versus ATF case, Judge Matthew Kaczmarek issued a preliminary injunction which blocked the brace rule in its entirety while the case proceeds forward. This decision by Judge Kaczmarek springboarded off of that recent decision by a different judge, Judge Reed O'Connor, in the Mock v. Garland brace case. However, in the Brito case, the judge there, Matthew Kaczmarek, went the extra mile and granted a request for an injunction against the entire pistol brace rule, and that was a nationwide injunction. A preliminary injunction is a temporary form of relief that remains in place until a case is fully decided on the merits of the arguments. So this order by Judge Matthew Kaczmarek and then also Judge O'Connor simply blocked the enforcement of the brace rule only until the cases are fully decided on their merits. And right now, there are a bunch of lower courts, including in the Mock case, in the Brito case, and a bunch of the other cases that are moving towards a final merits decision. And there are cross motions for summary judgment, which are trying to resolve those cases. But the important thing to keep in mind with the Brito case is that the decision in that case was based primarily on the Mock v. Garland prior decision that the Fifth Circuit had issued, and then also the district court below then followed. Originally in Mock v. Garland, the Fifth Circuit reviewed the case and found that Judge O'Connor should have granted an injunction to FBC at least on their APA claims, on their Administrative Procedure Act claims. The Fifth Circuit decision found that FBC did show a likelihood of success on the merits, which is one of the main factors to get an injunction and block this type of rule. The Fifth Circuit did not decide all the factors for an injunction because, again, there are multiple factors to get a preliminary injunction, but they did find that FBC did show a likelihood of success on the merits, which is the most important part of that injunction test. And so it was remanded back down to Judge O'Connor. On re-review, Judge O'Connor was simply just trying to find if the three remaining factors were there because he was importing the likelihood of success on the merits aspect. And on re-review, he said, yes, all the factors were met, and therefore he granted a preliminary injunction which protects FBC and their members, which that's going to be important going forward for what the ATF is now requesting. They also granted an injunction that protected the company there, Maximum Defense, and their customers. As I mentioned, the Mock case was kind of the first major pistol brace win, and then that set the stage and kind of snowballed into a bunch of other wins, including the Brito nationwide preliminary injunction. The ATF now argues in their appeal to the Fifth Circuit that the lower courts in cases like Brito were incorrect to use the prior Mock decision to show that there was a likelihood of success on the merits. The ATF argues that the nationwide injunction is overbroad also, and therefore the Fifth Circuit should reverse how that lower court ruled and essentially just remove that type of relief. In their recent brief, the ATF argues that 3 of the 4 pistol brace decisions properly limited relief to the named plaintiffs, although extending relief too broadly to organizational plaintiffs. But one district court went further. With no analysis, that court entered nationwide relief, staying the rule. And it did so based on a claim that plaintiffs in that case affirmatively disavowed. This court should reverse in Mock, Brito, Texas gun rights, and Texas. The merits analysis of the Brito and Texas gun rights district court fail, and each district court made fundamental errors concerning the availability and equitable relief and the scope of any such relief. At the very least, this court should vacate the nationwide stay, which flouts bedrock constitutional, equitable, and administrative law principles. Essentially, what the ATF is arguing here in their brief to the Fifth Circuit is that the lower court cases granted too broad of relief, and also that case, like Brito, incorrectly relied on the Fifth Circuit's prior decision in Mock. Now, one of the interesting things that the ATF is claiming there is that, at least in the Brito case, the court there, Judge Kaczmarek, granted the injunction and said, he was using the Mock decision that was issued prior by the Fifth Circuit in the whole APA violation claims and the logical outgrowth test that was in that Mock decision. The ATF is now claiming that those types of arguments were never brought in the Brito case, and therefore Judge Kaczmarek relying on those arguments in Mock was incorrect. The ATF then goes on to argue that even if the likelihood of success on the merits was present, they believe that none of the parties can show that this brace rule creates an irreparable harm on the plaintiffs or any of the public. The ATF states that no plaintiffs have demonstrated irreparable harm from the rule. The district court's conclusion that the individual plaintiffs will suffer irreparable compliance costs fails, both because the NFA's requirements are not sufficiently burdensome to constitute irreparable harm, and because the rule's compliance options permitted them to avoid much of the burden of those requirements anyways. And plaintiffs cannot manufacture irreparable harm by choosing not to comply with the NFA or the rule and then complaining about the consequences. And then they go on to say that nor were the district courts correct to conclude that plaintiffs' mere allegation of Second Amendment violation was enough to demonstrate irreparable harm in the absence of any determination by the court that plaintiffs are likely to succeed on their constitutional claims. The ATF essentially argues first that having to pay the NFA tax and go through the process of the NFA is not an injury that meets this type of burden to get an injunction. Also, they tried to wiggle out of the whole injury claim and the irreparable harm claim by saying, well, we also waived that tax stamp when we created the rule, and so there is no injury. You can't say that there's a tax injury because we waived the tax stamp. They also say noncompliance and potential criminal convictions because you don't qualify and you don't go through the process. That doesn't qualify as an injury. And finally, they argue that the allegation of Second Amendment violations also is not enough to prove irreparable harm. So a violation on your constitutional rights is not enough. Now, the most concerning thing that the ATF is asking for in this appeal is first that the nationwide injunction that was issued in Brito, that be removed. The ATF argues that the nationwide relief was beyond the lower court's authority, and therefore the Fifth Circuit here should remove that nationwide protection. The ATF is also asking that the Fifth Circuit remove the protections that were granted to all the 2A organizations. They argue that FBC, GOA, SAF, and others, all their membership protections and the injunctions that were granted to protect their members should also be removed. The ATF argues in their brief that the organizations like GOA would have to identify every single member that is impacted by the brace rule and potentially also name them as plaintiffs in this lawsuit. And until they do that, they should not get protections for all of their members. This, of course, is absurd, but that is the position that the ATF is making. They also state at one point in their brief that if a member of any of these organizations wants to be covered by an injunction that is granted, well, then that individual would need to come to the court and identify themselves with the court, potentially become a named plaintiff, or at least say, hey, I want to be covered by this injunction. Now, that's very interesting because the ATF claims that would be the cleanest and most equitable way to do this. Of course, that's silly to expect thousands of people to come to the Fifth Circuit or come to the lower courts in Texas and say, hey, I want to be also covered by this injunction. All of this is, of course, very concerning because the ATF first is trying to now remove that nationwide injunction that was granted in Brito that is currently protecting a ton of people, and at the very least, they want all these 2A membership injunctions to also be removed. Now, in my opinion, I think maybe it's possible that the nationwide injunction is removed. I think that's still a long shot, but I do think at the very least, the Fifth Circuit will still keep the 2A memberships in those injunctions in place. I don't think they're going to just strip all the 2A membership injunctions. I think it's absurd to say that all these individuals, all these members would have to identify themselves, become named plaintiffs to be covered. I think that's absurd, and I don't think that's going to happen. I think at the very least, the membership protections will remain in place during this appeal. So that's what's going on right now with the pistol brace issue. It's very interesting to see how this is developing. The ATF right now is attacking that nationwide injunction and trying to get it removed. Of course, if anything changes, if anything happens, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help us fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.